Well, good afternoon. And I hope you won't be too disappointed if I start off saying, well, I may not have all answers to all your questions. And unfortunately, for those who have more interest in privacy law, I've designed my talk this afternoon more towards IP law, because this is really my field of expertise, and privacy I only know by osmosis of my other colleagues at the Institute. So sorry for those who have more interest in privacy law. Now, this afternoon, I mean, we've talked about it all day already. Copyright issues keep popping up. So now I'd like to just separate a bit between copyright and the sui generis database right, because this hasn't been mentioned today, but in my humble opinion, I think that we should not underestimate the database right. And so I'd like to talk about it a bit and then conclude with what are the questions and how we can go forward. So what's the problem? Now, the problem is that text and data mining involves access to and usage of articles and data in bulk, which may infringe IP rights. So, and this is the problem as set today, and we'll divide between copyright law and database law, and give you a bit of how the law is interpreted and how it works, and then we'll go to the debate afterwards. So you've had today several examples of how scientists work with data and texts, and they deal, therefore, with a vast array of different material. And especially the last presentation, we've seen they work with video material, with texts, with even gesture, as I'm talking with my hands here. So what does copyright protect? Now, copyright protects original works and does not protect facts and ideas. So shortly, copyright protects, of course, expression of ideas and not ideas or facts. So basically, data as such, and in the example that we were given in biomedical research, the data generated by the research as such would not be copyright protected. Articles describing and interpreting and analyzing the data would probably attract copyright protection because it probably is original, but the data as such is not copyright protected. Copyright law may also protect compilations of data, and that's where that's the first bullet point. Compilations may be copyright protected as long as they are original, and the concept of originality is not harmonized in European law, not in the legislation as such. Now, the Court of Justice of the EU has rendered several opinions where it is on its way of harmonizing the concept of originality throughout Europe. Basically, the criteria retained is that a work, either compilation or individual work, must bear the author's own intellectual creation. Now, some countries have a bit stricter copyright originality concept, and others have slightly lower concept of originality. But basically, at the European level right now, on the basis of the jurisprudence of the Court of Justice, a work will be copyright protected if it bears the author's own intellectual creation, which, again, to put an example, sets of data and results and survey results or experiment results will not be protected, but articles interpreting them will. Now, what do you get when you get copyright protection? Now, we all know by now we get a right of reproduction and a right of communication to the public. Those are defined in different ways throughout the European Union and leads sometimes to different interpretation. But the right of reproduction is a very broad right of reproduction, and it includes all permanent and temporary reproductions on all medium whatsoever, and it also includes adaptations and translations. So you can imagine it's a very broad right. And the right of communication to the public, well, it includes more well, it was mentioned in the presentation this morning, it includes distribution rights, and the physical distribution of tangible copies of a work like books or CDs or DVDs, but it also, of course, includes communicating the work immaterially, either through broadcasting or making it available online. So you see online for text and data mining, both rights are relevant because you basically make a, well, depends, sorry, I'm just a jurist, I don't do text and data mining, to be honest. But I imagine that you do make a reproduction, and at some point you will also communicate the results in some way or another. So basically the basic right that's involved in text and data mining is the reproduction right, and to some lesser extent, but still relevant, is the right to communicate to the public. Now, moral rights are less relevant, but they do exist. So I mentioned them, especially the right of paternity and the right to have your name mentioned with the work, and the right of integrity. Now, here I make a difference between the content and the compilation. Because, well, the term of protection of copyright, we all know, it's way too long. It's the life of the author plus 70 years after the author's death. But if you have a compilation, you know, you can have a compilation, if the compilation itself is original, the compilation will be protected by copyright for the same duration. So you can have a compilation of raw data. If the compilation, the arrangement and selection of the raw data is original, the compilation will be protected for the duration, but not the raw data. And the other way around, you can have a non-original compilation, but original content of articles or paintings or videos or recordings. So you need to bear in mind that the compilation, if original or not original, will have a term of protection and the content in it as well. So we had the example, don't know where the colleague is now sitting, of work, text and data mining of medieval documents. Well, in all likelihood, if the medieval documents are original documents, they are no longer protected. But if they are recent translations, they will be. So now the core of the discussion will be around the exceptions and limitations. Now, what kind of limitations can we invoke, perhaps, to justify text and data mining? I have 3 in mind, but they are limited to some extent by the interpretation of the courts. The first one is incidental and transient reproductions. The wording in the copyright directive, which was taken over by almost all national legislation, is that making of a transient and incidental copy for allowing a technical process to take place or to allow a lawful use will be allowed if it has no independent economic significance. Now, this limitation has been interpreted by the Court of Justice of the EU in one case, and the Infopack case, and I'm not sure whether text and data mining would pass muster of this exception. It depends on the technique used. It also basically depends on how long the copy is made. I mean, taking for granted that you make a copy when you do the text and data mining, you do make a copy. Now, the exclusive right is broad enough to include, to cover that type of copying, and I'm not sure that this exception would be relevant, or at least would apply in this case, because it is possible that the copy that you're making lasts too long for this exception to apply. Another exception that might apply might be the right of quotation, But again, there are distinct difficulties with this because a quotation involves the use of the original text in another work. And when you text and data mine, you actually aggregate the knowledge drawn on the basis of thousands of texts, so you don't make a quotation. So any way you interpret the quotation right, I don't think it might apply. And the last that might be relevant for scientists anyway could be the educational and research use. Logically, it sounds interesting, and you might think, yeah, researchers do research, so this limitation should, you might think, apply. But the wording of this limitation in most countries is that a use will be allowed if it's strictly for illustration in classroom or for illustrative purposes and research. And actually, there's absolutely no case law that reached the Court of Justice of the EU on the educational use exception. At least I'm not aware of any case. And at national level, this limitation is interpreted usually rather restrictively. So the educational use exception will be usually for classroom use. In some cases, you may make a couple of photocopies for the amount of students in your classroom. But to think that text and data mining might fall under this exception, especially because of the wording that it has to serve as illustration for teaching, is doubtful. Now, in Germany, there might be one limitation that might be applicable, but I don't know, the 52A. Yeah, but that's very unique to Germany.
Okay.
Yeah.
You can make the copy as I understand it, but then sharing it is the problem?
Yeah. Yeah, but it's less a problem in Germany than anywhere else in the European Union. So Germany is the most forward-looking or accommodating for researchers of all countries of the European Union. So basically, the bottom line is, in my opinion, in my honest opinion, those limitations, because of the way they are worded in the directive and as implemented also at national level, most won't apply. And this brings us to the database, right? It hasn't been mentioned yet, and I don't know if that's because people are not so aware of the existence of the database right, and it's not a global right. The database right is really a unique right to the European Union. It was created by a EU directive in 1996. And the database right creates a new IP right that protects databases, as the name says. Databases that show that there has been a qualitatively or quantitatively substantial investment in obtaining, verifying, or presenting the contents of a database. So the database really protects the investment. It's not a creativity right, it's really an investment right, and it protects investing in creating or in obtaining and verifying data. So to go back to other examples, if the compilation, you know, whether it's a publisher or whoever else creates a database, they might have an independent right on that database from eventual copyright protection on the database. So a publisher, by making whole the corpus of articles available and data available, might claim in Europe a database right on that database. So that's why I find it important to not forget the database right, because having exception perhaps on the Copyright Act, it may not be sufficient, and we need to think of the database right. Now, the rights of the database right are equivalent to those of the copyright, although they're called differently. So the reproduction right would be the right of extraction, and it's just as broad as the reproduction right. and the right of reutilization, which is also just as broad as the right of communication to the public. But there's also, and those right of extraction and reutilization, they relate to the reproduction or communication of a substantial part of the database. So if you only reproduce an insubstantial part, a limited part of a database, that's allowed without permission, but a substantial part would require prior authorization. And as far as I understand text and data mining, you do extract and reutilize substantial parts of a database. If you go text and mine thousands of documents to produce a research. Another part of the right which is worth mentioning is the repeated and systematic extraction and or reutilization of insubstantial part of the content may also constitute a database infringement under the European directive. Now, and what about limitations? There is no equivalent to the incidental and transient copying exception. There's no quotation exception, but we all saw that under copyright it was not really relevant anyway. And the educational use exception, well, is basically worded the same as for copyright law, and it's for purposes of illustration, for teaching or scientific research, as long as the source is indicated and to the extent justified by the non-commercial purpose to be achieved. And, well, therefore limited application most probably, although there again there is no case law. And this limitation of the directive is optional and has not been transposed in all member states. Now, in a proportion of the member states, but not in all. So basically, if we summarize, rights most probably subsist in database and or their content, depending what we're dealing with. If it's a corpus of articles, then probably copyright subsists in the articles, and if you have an original compilation, then perhaps also in the compilation. And you will probably have a database right subsisting on the database, on the structure of the database itself. Exceptions and limitations are hardly applicable. Scientific publishers claim or tend to claim copyright and database protection on the content of the database, and the result is, in my opinion, as far as I can see, is that text and data mining is usually not allowed without prior authorization from the rights holder. Now, the question is this one, really, and this is what we discussed earlier today. Should text and data mining be subject to the authorization of the rights holder? And I know that time is flying. And the basic question is again, I mean, I only have questions because there's as yet no answer, really. From a normative perspective, it's clear that not all technically possible reproduction should be considered copyright relevant acts. So there should be a limit between what's technically possible and what's legally falling under the exclusive control of the rights owner. So, and where is that limit? This again, personal opinion, there is no case law, but I believe that text and data mining for research purposes does not encroach upon the normal exploitation of the work. It does not unreasonably prejudice the legitimate interests of the rights holders, because publishers have never invested or have never geared their business models towards text and data mining. Their core business is to offer publications, but not to allow text and data mining. And they do prevent innovation and prevent science from going forward with this attitude. And there are possibilities of building in safeguards if needed, and these are measures that I took from the UK suggestions. And I have 1 minute left, but this is my last slide. So basically, the law is not clear on the extent of protection of the types of databases that we were dealing with. Database and the source that are being used by scientists to do the text and data mining vary tremendously from the beta to to the human sciences, and from texts that are in the public domain, raw data that's in the public domain, to compilations that might be protected, to databases containing articles that are protected. So it is uncertain. What's pretty certain, I think, but still my legal opinion, is that exceptions do not apply at this stage. So I find that for legal certainty, there should be something done about it. And the question, another one, that remains is, well, in what form should this be dealt with? Should it be dealt with as a specific exception for text and data mining, or should be included in a broader exception or copyright reform? I suggest that text and data mining is not the only issue to be dealt with at this stage. There are other issues being discussed at this stage. User-generated content is one, and I think that if we go ahead with copyright reform and exceptions and limitations, we should take everything into consideration at once and not just aim at one single exception. And my time is up, so thank you very much.
Two questions, okay. I've seen, I'll just, you know, I'm Fred Friend, and Peter already had a question today.
Yes, I suppose, is this on? Yeah. Oh, great, okay. I think, I mean, you probably agree with what I'm saying here, but in a sense, I mean, that was an authoritative and expert application of what one might see as a somewhat outdated analog framework to a new digital environment. And I guess in the context where virtually all interactions or transactions over the internet involve the sort of transmission or replication of you know, data, and that even surfing the web, your web browser will effectively cache and store copies of that website for potentially a long time period, just to mean you can access it more quickly and don't have to download all the photos and all the rest of it. It kind of demonstrates that, as you say at the end, that there is a need for a grand-scale migration to harmonize public practice with the actual copyright framework. And sorry, I had a very small second part of that, which is just that if there are no exceptions and limitations for applying to text and data mining, then surely the business models of Google and Facebook, in terms of their use of the data that they receive, are, you know, also run foul of those, you know, run into problems as well.
I'm not sure about that. I mean, the data that they get from the scientists, usually scientists who publish with those big publishers, they sign contracts transferring all rights on the article and on the data.
I was meaning more just the you know, status updates and the sort of, you know, which you would obviously have copyright over your own text that you enter into all these websites, and yet if they're using it for commercial benefit through mining all that, then surely they run, if there's no exceptions and limitations to that material. Yeah.
That's when the servers are in America.
Yeah.
No.
Friend, Lucie, you contributed to a very thorough and valuable study on this topic for Open Air, and and I'd recommend anybody to read that. It's 130, 140 pages, something like that. Yeah. But they're preparing a shorter version, which will be available soon. But my point is that when this was presented to the Open Air Review panel in July, we were very concerned about the issues that you raised, and we put in a recommendation to the Commission that some action should be prepared on these topics, because otherwise the Commission and citizens of Europe are not going to get the full value they could from the investment that the EC is making in services like OpenAir, indeed almost any digital service that the EC provides. And that, from our recommendation, as Jean-François said earlier, that is now in progress, as it were. But one good thing that I saw in what you talked about is this substantial investment point in the sui generis database legislation, because the Commission is making a huge investment in making content and data available, and therefore, from my point of view, I would say that substantial investment should give the Commission some rights, or to be able to allow some rights in the use and reuse of the data, including services like TDM. Am I right to be optimistic about that, or not?
I would say that that would be correct, as long as the European Commission is the owner of that database. Therefore, I believe that probably what is produced under open air money probably would fall under this, but still doesn't help all the researchers who rely on access and possibility of reuse of material held by publishers.